In light of the current market capitalization of cryptocurrencies, the movie offers a short picture of the situation. If you are interested in keeping up with the most recent information regarding XRP and other cryptocurrencies, you should also click the like button and subscribe to my channel immediately. According to what the United States Securities and Exchange Commission USA asserts in its lawsuit over XRP, a brand new cryptocurrency airdrop is currently taking place on Telegram and is scheduled to start at any minute. Participating in this airdrop is something that you should strongly consider doing. This opportunity is there at your fingertips. The link to it may be found in the description of the movie. The following section of our film is about to begin, so please be prepared. As part of the process, the XRP has taken another step. Ripple has taken the next step in its ongoing legal struggle with the government agency by submitting an appeal notice to the Second Circuit Court. This is the next move it has done in the battle. Nobody in the XRP community is aware of the particulars of the SEC's appeal with regard to the cryptocurrency. Concerned parties from the Securities and Exchange Commission may launch an appeal against Ripple's remedial judgments on the $125 million penalty, according to news articles. In the meanwhile, the United States government seems to be considering this possibility. In its notice of appeal, which was submitted earlier this week, the securities regulator did not specify specific themes they intend to oppose, despite the fact that they did declare that the final verdict would be announced on August 7th. In the XRP community, this is the primary reason why there is still a great deal of uncertainty. Ripple is expected to pay $125 million for institutional sales on August 7th. According to the paperwork that has been filed, this is the case regardless of whether or not the SEC chooses to challenge the limitation on programmatic sales. The United States Securities and Exchange Commission, on the other hand, will file an appeal against the final ruling. In accordance with the ruling, Ripple was compelled to pay a fine of $125 million on August 7th, regardless of whether or not the blockchain business provided their agreement to this payment. Was unhappy with the decision-making process that resulted in the Supreme Court's conclusion in the case of Ripple v. CCCC, mainly due to the fact that the regulatory body had previously demanded that Ripple pay a fine of $2 billion before the ruling was ever made public. According to a previous remark made by a journalist for Fox Business, the regulatory agency that is involved in the case of Ripple v. Securities and Exchange Commission (SEC) has not yet submitted its Form C to the Second Circuit. This form would include any additional information that pertains to the appeal that must be specified. She requested that the company take immediate action about this matter so that they may offer Ripple with detailed instructions regarding what they should do next. It is 2. To make matters even worse, Ripple is required to file a cross-appeal to the XRP lawsuit no later than 14 days after the day this article was written. Is that the way things ought to proceed? The question of potential completion dates for the Ripple litigation has been brought up by a great number of Bitcoin attorneys in the past. It is not anticipated that the Second Circuit Court will issue a decision until the beginning of the year 2026, at the earliest. In the event that the parties are able to reach a consensus, the appeal may be dismissed, according to Fred Rispoli, an advocate for XRP. The Form C declaration that was submitted by the United States Securities and Exchange Commission has not yet been received by the Second Circuit. This particular form is required to provide all of the pertinent information on the case that the agency intends to appeal after reviewing it. The Securities and Exchange Commission, sometimes known as the SSE, is the body that comes next. The next steps in responding to this summary ruling from July 20th, 2023 are yet unknown. This is due to the fact that the judge decided that Ripple's cryptocurrency, XRP, was not a security. The corporation achieved a significant victory as a result of the litigation regarding secondary sales. According to the Securities and Exchange Commission, the appeal was submitted on October 2nd. A significant drop in the value of the most widely utilized cryptocurrencies was brought about as a result of this. The chief executive officer of Ripple, Brad Garlinghouse, was forthright in his remarks regarding the news. Through the use of the word infuriating to describe the appeal, he gave the impression that he was accusing the agency of being corrupt. Despite the fact that Stuart Alderity, Ripple's top counsel, has stated that the company is open to the idea of cross-appeal, there has not been a decision made about this topic as of yet. Now Ripple is investigating all of the opportunities that it presents. There have been 2 weeks since the deadline for the corporation to submit its counter-appeal. The National Security Council brief must be completed by the beginning of December at the very latest. According to a post that attorney Fred Rispoli made on social media, the date that is anticipated for the oral arguments is scheduled to take place in the latter half of the year 2025. Rispoli has stated that a decision will be taken in the month of April in the year 2026. During this same time period, the price of XRP has continued its downward trajectory, falling by 0.9% during the course of the previous day. Because of the application that was submitted to the SEC, the value of the token experienced a drop of double digits this week. A ripple effect was caused by the United States of America. An appeal notice was issued by the Securities and Exchange Commission on October 2nd in response to a verdict that was handed down by Judge Anisa Torres. Following the decision that was made in 2023, which said that purchasing and selling Ripple XRP on secondary marketplaces does not constitute selling securities, the legal world had anticipated that the regulatory body would file an appeal. The Judge Torres came to the conclusion that XRP by itself does not qualify as a security. It was due to the digital that this occurred. Currency is not subject to the Howey test, which is utilized by the Securities and Exchange Commission to differentiate investment contracts from other types of financial assets. According to Torres, secondary transactions were not considered to be unregistered sales of securities because of this rationale. On the other hand, she was successful in determining that the process of selling Ripple tokens to institutional investors ought to be taken into consideration. As a result of its deployment, sales of security assets have occurred. Ripple Labs and the cryptocurrency industry as a whole were exuberant in their celebration of the verdict at the time. Gruber Gruhl, the chief enforcement officer of the police department, resigned in accordance with the established protocol. Gruhl has been accused of imposing stringent enforcement measures on the Bitcoin industry due to the fact that he proposed more than 100 different enforcement actions during his tenure. In addition, they asserted that Gruhl was employing these strategies on October 11th, which was the same day that the agency filed its notice of appeal in the Ripple dispute. However, the government regulator has not made any public pronouncements regarding Gruhl's resignation, despite the fact that continued efforts are being undertaken to identify a permanent successor. Sanjay Wadhwa, who is now working as the deputy head of the enforcement division of the CC, has been appointed to the position of interim top enforcement director because he now holds the position. During this time, it appears that XRP is causing something of a stir among well-established institutions. Cointel's data indicate that on September 30th, Bitwise made a request to the state of Delaware to establish the FRXRP Exchange Traded Fund ETF. The FT4XRP ETF is currently being investigated by the company at this time. This document was made available to the public by the state's Division of Corporations, as it was revealed in it. His recommendation is that the initial filing in Delaware is not the same as the filing with the Securities and Exchange Commission. XRP trusts are another important factor. One possibility is that the CC's clearance will be delayed as a result of the most recent court appeal. Because of the position that the United States Securities and Exchange Commission takes with regard to exchange trading, Denton has been compelled to devote a considerable amount of time and effort to this subject of investigation. More than $75,000 of his own money was put in the currency, and he believes that the Securities and Exchange Commission ought to acknowledge the excellent attributes of the currency. The candidate contends that his request to the agency is basic and reasonable, taking into consideration the facts, relevant case examples, and the outcomes of those cases. It is Denton's opinion that the Telegram case establishes a precedent that is of great significance. In the specific instance at hand, the court came to the conclusion that Gram tokens did not qualify as securities. In the end, the court determined that it was nothing more than a code consisting of letters and numbers. The information that is presented here is not given with the intention of serving as trading advice. When it comes to any decisions about investments that are based on the information presented on this page, there is absolutely no legal remedy available. Before making any decisions on investments, it is prudent to obtain the guidance of an experienced and knowledgeable specialist and to carry out your own research.